All right, so we finished talking about these things. We are now on to this slide. So who is this? This North Carolina Real Estate Commission. What do they do?
Give you your license and tell you you can keep it.
Yeah, pretty much. Yeah, that's a pretty good summation. The North Carolina Real Estate Commission is the one to whom you will be applying for a real estate license. So as I like to say, they are the ones who give it, and they are the ones who can take it away. And that is pretty much the extent of their ability to discipline you. And so when we talk about disciplinary action, we're going to talk about the things that the Real Estate Commission can do to you. The biggest thing they will do, hopefully, is give you your license once you are eligible and have passed the exams. The worst thing they could do to you is take it away and revoke your license so you no longer have one. So in your materials, I noticed your materials were not quite up to date. So you may have the C in there. You can scratch out C. So there used to be 4 things they could do. They stand for reprimand, suspend, or revoke. And we'll talk about those, but reprimand, suspend, or revoke. The C was for censure, which essentially is we're going to close and warn, and so we just got rid of that, and now it's a close and warn, meaning nothing really happens other than don't do it again, we're just putting a note in your file. So reprimand, suspend, or revoke. Now that does not absolve you from court retributions. And so there are 2 matters in which if you are violating real estate law, you may be implicated on other things. One of which is the Real Estate Commission is going to do one of these things to you. So if you are found in violation of real estate law, you could be reprimanded, shame on you. You're going to go on the pages of shame on the back of the bulletin, which we'll talk about that. You could be suspended, meaning you still have a license, you just can't use it for a period of time. Or you could have your license revoked, meaning they are taking it away from you and you no longer have one, just like today. So one of these 3 things can happen from the commission. However, you may also be subject to court penalties. Someone could sue you and take you to civil court on a civil matter. One of the big examples of kind of both of these is that willful misrepresentation. You lied, violating real estate commission law. You could be taken to court and that person you lied to could sue you. So there are many levels at which they actually may pursue and go beyond just your real estate commission law requirements. So difference between what can be done. Courts are different than the real estate commission that you take home here.
You keep saying civil court, but I saw the word criminal up there.
Yeah, it could be criminal if it's bad enough. Yeah,
Okay.
Yeah, especially with trust accounts.
Yeah.
Yeah, if you were to identify a country with no extradition laws and take all of your funds out of a trust account and sit on the beach for the rest of your life, not that anybody would ever think of doing such a thing, you could be found guilty of federal violations as well and possibly even end up in an orange jumpsuit. Yeah. And there's some fair, yeah.
I imagine the majority of them are, I mean, you say civil, that's the, I mean.
Most of them are going to be minor offenses.
Yeah.
You might have to write checks. You may have to set someone whole, more of the compensatory damages that we talked about. But sometimes they're much more damaging. There was actually one of the biggest cases of federal loan fraud was right here in North Carolina. It was in the southwest part of our state. There were 32 people indicted on federal loan fraud violations.
Oh, these are the straw buyers with the appraisers and the attorneys and all that. Yeah.
Yeah, they had exactly that, and it was there was a lender on it who would loan money on a house to be flipped. The house was never flipped. They would find
People
a
were
straw
never
buyer. They would find the straw buyer that was either real or not real. The lender would give them a loan to turn around and buy the property at an inflated value, seeing that it's fixed now because the appraiser said it was. And then they would basically launder this money, siphon off the proceeds.
I remember reading about that.
Yep.
Florida, wasn't it?
It was North Carolina.
That was here.
Yeah, there might have been one in Florida too.
Yeah.
But it was a really big. It was one of the biggest. You can Google it, and it was a huge federal loan fraud. A bunch of people went and got some serious orange jumpsuits for jail. So it's not always just.
It wasn't just the laundering too. There was an issue because they raised the value of the houses.
Yeah, they did.
Messed everybody up.
Yeah, because it was messing with the market data. It had a real ripple effect in the marketplace. Yes, sir.
Would that have been illegal if they had paid cash?
Yes, because of the way they were doing it. And I guess it was as much loan fraud as it was just regular fraud too. And to let's just say it was cash. She pays $50,000 for a house cash. You would go find him and say, hey, I'll give you $5,000 to buy this house for $100. And he writes a contract to buy it for $100. He buys it from you for $100, but you didn't do anything to this. You made 50,000, he made some money to walk away, and you go do it again.
Yeah.
Let the house go to foreclosure or whatever you need to do.
And the problem is none of the actual work was being done. It was nothing really ever actually took place or changed hands.
They were flipping houses without flipping houses.
Yeah.
Yeah, and it obviously takes a lot of parties to lie to make that happen. So those could really end up in criminal charges too. So, principal. Your principal also has some duties to you, one of which is to act in good faith. They're going to hopefully be loyal to you, act in good faith. If they quit their job, they need to let you know. If they're not going to be buying a house or incapable of buying a house, they should probably let you know so that you're not driving, hoping and hauling and hoping, as my friend would say. What's his name? Bill Gallagher, sorry. I had a brain fart. Bill Gallagher's another instructor. If you guys ever get the opportunity to take a class with him, in your CE particularly, he's hilarious. And he'll always say, hauling and hoping, showing and selling. So hopefully, if you're going to be hauling and hoping, they can buy. And otherwise, they might not be acting in good faith. So they got some responsibilities to you, and hopefully to pay you for your services. Again, your agency agreement is going to dictate what you get paid and who's paying you. So that's what we're going to be looking for, how you get paid. Liability. So there's the liability of the principal. So this is kind of in conjunction with what we were just talking about. They could be found for fraud, lying, false promises. The courts could pursue any parties to a real estate transaction that are found guilty of these type of violations. One of the biggest things that we could run into in this capacity is in the listing side. We're listing a house for sale, and the property disclosure, the residential property disclosure statement, says, hey, do you know anything wrong with the foundation? Nope, because they covered it up with all them bookcases, so you couldn't see it. So they knew about it, they lied about it, that's fraud. So now, could they have said no representation? I don't know. Yes, the seller can. They cannot lie. And as brokers, if we see them lying, we need to advise them, hey, not a good idea. Not a good idea. You could be found guilty of fraud for lying, falsifying this information. So make sure you're having these conversations and make sure they know that they're supposed to be honest and forthcoming with information as well.
And you wouldn't have had an obligation to move the bookcase.
I would not have had the obligation to move the bookcase, yeah, because and neither would a home inspector, which is how those things get by, and sometimes they may not get by until the last walkthrough, if you did the walkthrough, which you should always do. Yeah.
So is the disclosure worded, to the best of your knowledge? Is there anything wrong with the foundation, or is there anything wrong with the foundation? Because then I don't know
Yeah.
is, to the best of my knowledge, no.
Right.
There's nothing wrong with it.
Yeah, and choose to the best of your knowledge, and it is,
Okay.
you actually have a copy of the exact verbiage in the form, you have a sample copy in your book, but it is really, hey, Mr. Homeowner, tell me about the age of the house, approximate age of the house, approximate age of the HVAC, what do you know? Is there a problem with it? Yes. Is there a problem with it? No. Or is there a problem with it? No representation. I don't know, or I'm not saying. And so they have the option of filling one of those three.
Yeah, I'm just saying that I don't know,
And
if
that's,
it's to the best of your knowledge is no.
and that's the conversation you'll have with your sellers. If you don't know, no representation might be an okay answer. Because I would not want you to say, oh yes, the roof is 5 years old, when really it was actually 15.
Sure.
And they guessed wrong. So if you don't know, it's okay to say no representation. The seller can do that.
And magically, that crack just happened to form right behind that oddly sized bookcase.
Yeah, yeah.
That we didn't see until you moved.
Yeah, and sometimes that does actually happen. I think we cited the case with like the rugs on the hardwood floors, right, where the floors get faded, and maybe they've been there 15 years and they haven't ever moved that rug. It probably shows. So you never know. Sometimes it is, I just didn't know, and they're not going to be found guilty of. And let me rephrase that. A lot of this, did you lie, goes to court. And in order to go to court, someone has to provide evidence. So the burden of proof shows up. That's beyond our scope. We get attorneys and things. But we do have to advise them that they could get in trouble if they do lie. And that's what we're trying to prevent. Let me get you and then you.
What if you had a leak in the basement, for example, but you got it fixed during your time in the house? I mean, do
So
you
it's
mention
okay.
that?
It's okay to tell them. Yeah, we had a leak, and actually you'll run into this a lot because they we don't have any in here. Almost every ceiling I walk into has a little brown water spot because something has leaked somewhere. And so that's the first question I'm asking. I'm like, hey, I see a water spot there. Did you have a leak? Yes. Did you fix it? Great. That's all we need to know. It's okay to tell them and say, hey, yeah, we had the bathroom upstairs did overflow. We had it fixed. It no longer is leaked. It's been that way for years. Here's the plumber who fixed it. Nothing wrong with saying that. Yes, sir.
Is there like a time frame though, like if a deal is done and they find something like that?
That something's come up? Nah, so that falls under the statute of frauds and how long can it happen? Most of the time there is not. Now what does happen is it gone so long that there's no longer evidence? And that is usually the case, but I'd say 7 to 10 year windows probably are still open, pretty open windows, as long as you, especially with our record retention law, which is how long?
3.
3 years. So at least within 3 years, we're gonna have to have pretty solid documentation. Beyond that, it would be harder to prove. Not impossible, but harder.
But as a broker, it's not your job to like go in the house and like look under rugs and look behind this, and this, right? Isn't that like the inspector's job?
Yeah, I mean, we're not gonna pick a house apart. We're not gonna,
Yeah.
we're not home inspectors.
Yeah.
We're going to do the walk around and look for the obvious stuff, the really plainly or patent defects. We're not gonna be poking holes and lifting stuff and moving furniture. That's just not our responsibility. That's a good question.
Inspector's not necessarily doing that stuff either.
Yeah, they may not. Yeah, because they're only if you've got a antique bookcase in front of their wall, they are not moving it.
Yeah,
They will
well,
not.
I mean, you know, I happened to be there when I purchased my house, and the inspector was there, and he's like, well, I can't make any statement to the plumbing because the water's not on.
No.
And so I said, well, give me a minute, and I'll go turn the water on. I mean, you know, it was just turned off at the faucet because, you know, they just winterized that. And I'm like, no, you're gonna test it, and he's, you know, same deal with the air conditioner, the main was off. There was power going to the house, the main was off. It's like, no. He's like, you can turn it on, I just legally can't turn it on.
And that's actually a real, we talk a lot more about those specifics in post-license, but that our offer to purchase and contract says that the seller will provide utilities so that when I bring my inspectors, I can test all these things. So you as listing agents have this conversation with your sellers as a part of their responsibility. Hey, we want to make sure the house is ready for inspections. And if it's not, the buyer may have the right to either ask you to turn it on, or again, caveat emptor, they may have to say, I'm going to have to move forward and decide whether I want to terminate based on the fact that I can't do the research that I want to do, or go ask you to turn it on and come back. And I've personally paid for a reinspection fee for a home inspector because my sellers, we had this conversation multiple times in writing, in emails, hey, you got an inspection tomorrow, blah, blah, blah. So we have it all. Still, they had a gas fireplace that they didn't use, and so they never had it turned on, and it was connected, everything was there, they just never turned it on, and the buyer really wanted to inspect it as a part of their due diligence, so they did everything they could do except the fireplace, and I paid the man $75 out of my pocket to go back and inspect that, because the seller should have made arrangements for that to be on. So, and they will not light it. If it is not lit, home inspector will not light the gas because they might blow it up. If the water's not on, they can't turn it on because if there's leaks and they flood the house, they don't want that liability. So we want to do our best as brokers to prepare both parties on how this goes and to be as adequately prepared as possible for everybody. I saw your hand.
Oh, no.
No. Okay.
Never mind, sorry.
Okay, change his mind. All right. What's a broker allowed to do on your behalf? Well, it depends. And the answer there is always going to be, it depends. Why? Why does it depend on what I can do on your behalf?
It depends on your role.
Yeah, how much do you want me to do? What's my role? What agency agreement do I have? So we're going to break that down very high level at first, and we're going to drill down a little bit. So first and foremost, let's talk about this universal agency. Universal agency is usually in the form of a power of attorney. This means you are acting on behalf of someone as if you are them. These have to be, obviously, for very obvious reasons, be cautious. Because unless you trust someone to the nth degree, you probably don't want to give them a power of attorney over you, because that means they have your bank accounts, they have your social security, they have everything. Now there are times when it's appropriate. Maybe you're taking care of elderly family members and you need that. Or you have a service member who is out of the country and cannot do any of that, and you need to be able to act on their behalf because they're not here. So there are times when this is appropriate. In our world, the real estate agent may run into a power of attorney in the event that you are the listing agent signing the closing disclosure on behalf of a seller. So there are times where that can happen, but it was with a limited power of attorney. We are not pulling the plug on anybody.
No general.
We are simply authorized to sign any documents in conjunction with the real estate closing that the buyer may need us to sign because they cannot be there. I'm sorry, that the seller may need us to sign because they may not be there. Most of the time, everything's done on the seller side before closing day ever gets here. There's only thing we're waiting for is the closing statement, which typically is we're waiting from the lender's information to finalize that. Be very, very, very cautious with this. Have protocols and procedures in place because this can get you in a lot of trouble. Yes, sir.
All right, so right now I'm dealing with purchase of a property, the one in Greensboro.
Yeah.
And the guy is overseas, he's in Saudi Arabia, right?
Mhm.
Could he actually give his power of attorney to his agent to sign the paperwork for him so we didn't have to deal with the embassy?
Possibly. Possibly. Yep.
Getting it executed and acknowledged properly is gonna be tough if he's out of the country.
I was gonna say it would
And
have been
have an
better if he
attorney
did it
here
before he
accept
left.
Yeah.
If he
Yeah.
did it before he left, probably.
Pretty much, it's probably, and because he's already gone, just about as easy to do documents as it would be a POA. But had he done it before he left, sure.
Gotcha.
Sure could have.
Okay.
And then we see that a lot with military. We're not. Some of you may end up at some point around Fayetteville or Jacksonville where you have a lot of military relocation. That happens a lot because one of the spouses is gone. You don't hear from them for weeks. Things come up. Someone needs a power of attorney here in the States to do things for them. Go pay their taxes, renew a license, take money to the bank, take money out of their bank.
Get
So.
paid extra for that.
Yeah, no. So, and by the way, in conjunction with real estate brokers,
Unless it says so.
you do not want to do this, and the Real Estate Commission frowns upon this. You do not want to do this unless you have to, because, and I'll give you a real simple version of an example. If you are going to closing and your seller is expecting $100,000 in proceeds from the sale of their house, right? They're yay, we got $100,000. And you are given this power of attorney to go sign the closing statement as if you are them, and it's wrong, and you sign one where they only get $75,000. Guess who owes them some money?
Ooh.
Because you signed it as if they did. They would not have signed that. They said, "Where's my 100? I was expecting 100. You got me 75. What just happened here?" You see how that can be a very costly, dangerous mistake. So for me, I have done this as needed, but I have a very specific protocol. Here is the document that I am signing on your behalf. Send it to them. When you have authorized that I can sign it, send it back with written permission for me to sign it, in addition to the power of attorney that I already have. So I am never signing anything they have not seen.
So you're doing that at the moment of closing?
We usually have it a little before. We usually have it, seller side, you usually get you can get it a couple days before it often.
Okay.
So I want to make sure, and it almost bit me one time where I preemptively signed, but that's just my protocol. I will not sign a closing disclosure until the seller has said, "Yes, you can sign this, Stephen. Thanks."
And they signed it at their end anyway, just so you have it on file.
Yeah, and I may actually send it to them through an electronic signature or something, just so I have a copy document, and they said that's okay to sign.
Yeah.
There's nothing wrong with extra protocols. So you just had to, and we live in a digital world, right? We talked about a lot of loan fraud and things that go on. We have a big target on our back because of the amount of money we move. So we have to be very careful with that and always have a procedure in place and follow that procedure. So that's universal agency, and this is a good example where someone's out of the country or military. Now, let's drill down a little bit further. So from universal agency, we drill down and we have general agency. A general agency, when you see general agency, I want you to think property management, because this is the type of agreement that exists in property management. It's not as broad as universal agent. It has much more limitations. However, you can do things under this agency agreement that you cannot do under some of your other agency agreements. So, first of all, the relationship is expected to be ongoing. And the reason I say remember property management is because when I sign a management agreement with you, "Hey Stephen, will you manage my property for a year?" Sure, we'll find a tenant and put a year in it. It has an automatic renewal clause. It says, "Hey, cool. This agreement will automatically renew ongoing unless either party terminates as prescribed in this agreement." So property management agreement is a general agency. It's expected to be ongoing. It does exist in the form of the property management agreement. And this is one of the biggest, probably, liabilities from this type of situation, is that you can, in fact, bind your fiduciary or your client to contracts. What does that mean?
Sign up for them on their behalf.
Yeah, I can sign leases on their behalf. I can sign a maintenance agreement on their behalf. I could send out a plumber and sign a repair agreement on their behalf as dictated in my general agency agreement, which is in this case my property management agreement. Also, independent contractor agreements fall under this category. So you're giving a little more authority, well, I should say a little less authority than universal, a little more than special, which we're going to talk about next. Questions on that one? In our world, general agency typically lives in one of these two lanes. Either our independent contractor agreement. By the way, where are we going to see this independent contractor agreement?
Your agreement with your brokerage firm.
Yeah, this is the agreement you will sign, because you will all be a licensed broker. You will all be an independent contractor when you get your license. So as an independent contractor, your independent contractor agreement says, if I'm going to do a job for you, i.e. sell houses, what am I getting paid? What are my expectations? What are my guidelines? This is your splits, right? How much of that commission that I generated do I get? That's in your independent contractor agreement. Read them. You would be amazed at when people sneak into these things and people are like, oh, that's so exciting, let's get started in real estate. And they sign it, not realizing there's a 2-year non-compete clause, meaning you can't practice with anybody else in the real estate world in this area for 2 years if you leave my firm. You might want to read what you're signing. Or you get 20% of all the commission you generate. This is where your splits and your agreements are set.
Are non-compete clauses even legal in North Carolina? I didn't think they were.
So they're not supposed to be, but if you sign them, if both parties sign them, and I say have you look at it and you look at it, they might have some enforceability.
Huh.
So it does infringe on fair trade and a bunch of other things, so they are very highly contested and frowned upon, 100% frowned upon. So I would, depending on how it's written, always consult with your attorneys, but never a good idea, and people will sign them. And it's not always in the form of independent contractors agreements. Sometimes we see it with administrative people. I have an administrator come along and they are privy to all my, what they call intellectual property, all of my systems, all of my databases, and now they leave me and go to my competitor and share all that. And
Financial
so,
services in general, I mean, when I worked at the bank, I had to sign one.
yeah.
I couldn't go work for another bank for, it was a year, but.
And so there are, and they do exist, and they have to be well crafted because, as you mentioned, they can become illegal. And one of the biggest, they usually end up being more of a confidentiality agreement, saying, hey, you know all my stuff, you can't go share it. But there's a big lawsuit right now, I think it was between Zillow and Realtor.com, because I think it was Realtor.com or Zillow, one of the others recruited somebody's CEO, and they knew everything, and then there was a big class action suit about you shared our proprietary intellectual evidence with this competitor, and
Yeah.
they sue the pants off each other.
Yeah,
Super fun.
confidentiality, I mean, that's fair game, but prohibiting somebody from practicing their trade, that's,
Probably gonna end up in court.
Yeah.
So, and that's why I said, people, and by the way, who writes these?
the brokerage firm.
Should be the attorney, but it could be the brokerage firm. You would be surprised at how many bubbas will just sit down and write their own. First of all, we don't draft. Also, mutual agreement might be it might trump it. So, and now whether it's valid or not, that's going to be up to the attorney. So, anytime you get into contract or contract signing, contract law, get an attorney. And this is what you're signing, a contract. Might be worth having somebody look it over. And then property management agreement. Good news is this is a standard form most of the time. We like property management agreements. We like our standard forms. They give us the authority to do what you would need to do as a property manager. Now, this is you. It looks just like you. Minus the gun. Those aren't safe. So first and foremost, I'd like to say you're all likely pretty special. You're special to me. You will also likely live in special agency land. Because if you are becoming a residential sales broker, you will live in the world of special agency and special agents agreements. Because a special agent agreement says, I'm going to hire you to do a job. When you do that job, we're done here. It is, I am hiring you to help me buy a house. Our agency agreement creates a special agency agreement relationship. When either our deal is done and we have purchased a home or our agency agreement has otherwise terminated, we're done here. You can't bind me to a contract. You can't sign my offer to purchase. You cannot sign my closing statement. You can't sign anything on my behalf. You are to gather information. Help me make good decisions. This is what we do. We don't make decisions, our clients do. We gather information so they can make good decisions. Questions on that? So you have universal, general, and special. Universal, power of attorney. General, property management typically, and special is going to be your sales listing and sales agreements. Buyer, seller, also in tenant, by the way. For the purposes of this class, the tenant and buyer rep are going to be treated pretty much the same way. Because in this capacity, you're helping someone rent a property, and this happens more so in larger metro areas. We don't have a lot of tenant representation in our marketplace just because it's not a real lucrative option for many folks. And so most of our people in this area can buy, but in places where real estate is cost prohibitive, like New York, Chicago, you don't go back, I'm gonna go buy a house in Chicago. No, you're not, because they're not for sale, and if they are, it's cost prohibitive because they're multi-million dollars. So you need someone to help you find somewhere to rent. If you watch Friends and Seinfeld and stuff, they're all like, oh, I got this apartment, right? I bought an apartment. Well, they got a lease. They didn't really actually buy the real estate. So independent brokerage versus broker. Broker versus brokerage. Now, this is just a vocabulary lesson. Broker is what you are, and you will work for a brokerage. Brokerage is another way of saying firm. Or you could see it in the sense of you're conducting brokerage activity, meaning something that requires a real estate license to be a broker. Now, this is what that looks like. Broker in charge oversees the brokerage. Independent brokers are independent contractors working at the real estate office. You, as a provisional broker, live here. And why do I think you so little and cute? Why are you so little and cute? Because provisionals are like children to a broker in charge. They have to supervise them. They watch every move they make. They comment, or I'm sorry, they have to be responsible for all the marketing. Everything that this person does, their broker in charge is just as responsible as a parent would be over a child. A full broker, which is what you'll be when you complete what?
Post-license.
Post-licensing, your 3 30-hour courses. So how many is that? 90 hours. So once you get through your 90 hours, you can then be a full broker, which is still going to put you working under a brokerage, likely. Your broker in charge, however, would like you a lot more because they are not as responsible as it would be as a provisional. Are they still responsible? Yes. Are you still responsible? Yes. We've all been to the same class. You know the real estate rules. We are all held to the same rules. Here we just know, as we mentioned earlier, you're just coming out of real estate school. You probably need a BIC to supervise and help guide you and make sure you're doing things the right way and not saying fair housing violations, etc. So this is what the broker in charge will help you do until you become a full broker, and at which point their supervision of you is not as micromanaged, so to speak. Does that make sense? Yeah.
Couple points, questions. So what's the saturation of broker, like in our area? What's the likelihood that brokerages are going to be hungry for new brokers when we graduate class, get our license, pass our tests, and all that kind of fun stuff?
That depends on how good of a friend you are with this guy.
Well, see, I thought we'd already all signed our agreement that he was just gonna hire us. And get it
Yeah.
done.
As soon as you get a license, we're good to
Get a
go.
license.
You all get the same salary, which is awesome because you know I was
Zero.
So one thing with provisional, being a provisional, some firms do not have the capacity to take on provisionals, and they will not.
Right.
Or they may have a limit and say we won't take any more. We're at capacity. We just don't have the ability to supervise that many provisionals. Because there is no rule as a broker in charge on the number of agents that you can supervise or the number of provisionals.
Well, I remember you said a number of like 175 or something that you're over here, and so if you're the one directly responsible for them, it's not like they can just go and do a lot of peer sharing and work off of that. You need to know what they're doing, so they're having to track you down. You can only handle so many before it's going to start slowing down transactions.
I really hope at some point that the Real Estate Commission does put some guidance on that says, hey, one broker in charge should not supervise
More than X.
X.
Yeah.
And currently, though, I could be the broker in charge for a 400 agent office.
Wow.
We have here 147 agents, and 27 of them are provisional. So that probably is, I can't say for sure, that's
And
probably a
you're
good
looking for
snapshot.
14 more, right?
Yeah. Well, by the time you guys get licensed, I'm hopeful the rest of them will be off of it because I want them to get those done. And by the way, you'll have about 18 months to do it, so it's probably pretty quick. But the provisional side of things is just a supervision. And I can tell you a great example today. Not to be too graphic, but I went to the restroom. I was like, I can go to the restroom. And on the wall above the urinal, they put all the announcements because we have to stare at the wall. And one of them was a beautiful flyer from a new agent in our office who just listed their first property. And it said 5-bedroom house, bring your family. I'm like, oops, let's take that down. So I took that down and I emailed them and they're like, we fixed it, so perfect. But again, as a provisional broker, that's my responsibility to have that conversation, say, here's the article about how not to do that, and this is a familial status. And there are sometimes you can flirt, and you'll see the example in your book, there's words that are like, you can say that, and there are some things you can. Does not mean you should, because it may still offend someone, or it still may fall on the issue of filing a complaint. But that's why I always teach, describe the property, because she said this is a beautiful 5-bedroom home. Let's stop there. Let's stop there. So those are the types of things that as a broker in charge you have to be on top of. The worst things that scare me as a broker in charge are not the flyers. It's what are y'all tweeting about, what are y'all Facebooking about, what are you texting about, the stuff that's in your pocket that I can't always see.
I know the stats racing question probably would have been one you asked before you even joined the class, but I was just curious.
Yeah, I mean, I think it's always going to be, right now it's a pretty healthy amount, but it has a natural attrition where one of two things happens in 2 years. You're either likely a full broker or you're out of the business. Yeah, so that's just kind of the natural timeline. And actually, as of July 1st, it's going to drop to 18 months. So within 18 months, you're either a full broker or you're out of business.
So how many do you think are in Winston-Salem brokers?
I mean, if we're indicative, if we use just total, or are you talking about just
Total.
provisional?
Brokers.
So in our local MLS, we have about 1,400 members here in Winston that are members of the Association of Realtors. Actually, I think it's a little bit higher now. Let's say 1,500 just to be a round number. And so we have about 1,500 here in Winston. Our MLS, which is inclusive of Winston, High Point, Greensboro, I think that's closer to about 6,000 total with everybody and all the surrounding counties. But that's a
And
lot.
how many conveyances on average are happening?
Our office here closed 213 transactions last month. I would venture to say there's probably about close to that, probably nearly
So it's one and
1,000 a
half
month.
each, give or take.
Yeah, yeah.
So how much a month is that?
I'd say we're probably pushing close to 1,000 transactions a month, and as an MLS, right around that mark, give or take. So the good news is,
You said with 6,000 people roughly?
You'll find, by the way, that 20% of the agents are doing 80% of business.
I was gonna say,
Well, that's in corporate world, 27 people do 80% of the work.
Yeah, it's
Doesn't change.
the 80-20 principle. It's been proven across multiple platforms. 20% of your efforts will generate 80% of your revenue. 20% of the agents will produce 80% of the results. And that's why you have these big producers, because they're doing more. And then you have a lot of little producers that I think the average real estate broker does 12 deals a year or less.
What's the average commission? I mean, I know
Here?
it's spread, but yeah, what's your average commission?
I think our average here is not that high. I think it was more like, I think, last check, our average here was something like, I usually use 3,500, 3,500 to 4,500 just as a budgeting for my,
We're doing 11 a year.
yeah, honestly, it takes about 2 million in volume to really, to make a living
A
in
decent-
our area.
Yeah.
Yeah. So, and so a lot of people, by the way, aren't here to pay their bills. This is I've got good income from a spouse, retirement, whatever. This is my play money. So if I do 10 or 12 or 1 or 2, that's just extra.
Gotcha.
And that's one thing you want to distinguish yourself. Hey, is this your full-time job? Because that's my sales pitch. I do this every day. If I don't sell houses, I don't feed my family. And that tells a consumer, hey, I take this pretty serious. And I have one co-broke who was selling my listing. I called her and she answered the phone, Wake Forest Health. I'm like, I must have the wrong number. I'm looking for such and such. No, that's me. That's what I do. I have to wait till nights and weekends. I'm like, this is not going to go well. And it was a very tough transaction. But there is a big difference between you're doing something full time and not. You guys know that, right? You wouldn't want to be like, hey, I need to get heart surgery. Is there anybody here who does that part time? I want someone that's done that a little bit. So full brokers and getting this provisional out of you, that's also going to give you credibility because it's going to say, hey, you've been doing it for a while, you've got that additional education. You don't have to be as micromanaged. And it helps your broker in charge sleep a little bit better at night. So that's just some vocabulary from how that works. The firm, however, is who all agreements are with. And this is a common misconception. So we have all these agency agreements. We have the buyer agency agreements, we have the listing agency agreements, we have the property management agreements. All of those agreements are with the brokerage, the real estate firm. You as an agent, via your permissions as an independent contractor, can bind the firm to those agreements. So if you take a listing today, you go in a listing appointment and you list that house, you are listing the house for your firm. That is your firm's listing. Your independent contractor agreement dictates, based on your efforts, how much will you get paid, what will you do, what will we do? Will you do your marketing, do we do your marketing? Who does the MLS input? Who does what? That's all dictated out in your independent contractor agreement. And ultimately, how much of that money you're going to generate do you get to keep versus what do we keep? That's important to know. Because do you think that every broker that starts in real estate stays with the same firm their whole life?
No.
They don't, and they move. So when you move to a different firm, what does your independent contractor agreement state about these agency agreements that you have procured on behalf of the firm?
They belong to the firm.
They do belong to the firm, legally. Their policies may say, great, no problem, we understand those are your clients. You can go and take them with you wherever you're going, but you're going to pay me a percentage of the commission when they close.
Oh, you're talking about in-process deals if you.
In the middle of processing?
Could be anything. It could be, I have a listing for sale. I'm like, you know what, I think I'm gonna go over to this other firm, see how I'm out. They're gonna say, great, we're keeping your listing, have a good time, thanks for that. Or, you know what, we understand, take it with you. Those people know you, they don't know me, I don't even have their phone number. You go list them with your new house or your new firm, we'll terminate, you can list with them. But when you sell it, you'll pay us an X% referral fee since it originated here.
Unless it's already been closed, obviously when it's closed, it's done and over, that's not the same situation.
Yeah, well, I should talk about that when.
Because I don't know if there's a time frame for, okay,
Yeah, because if it closes here,
yeah.
all that money is coming to the previous firm, and actually I may have already moved firms, and there's some special scenarios on how we can make that move. But it's all going to be dictated in your independent contractor agreement.
But what about in future contracts with the same client?
Also going to be indicative of your independent contractor agreement. Did you procure a listing or buyer lead that listed or bought with you later? And did you get it at this firm or did you get it at that firm? And moreover, how are we going to prove that? And that's usually the conundrum. It was, hey, you don't have an agency agreement, and we've told you if you don't have an agency agreement, you don't have an agent, you don't have a client, right? Typically, which we'll get to in a minute. So those are all going to be specifics
Oh, I see what you're saying.
of your contractor agreement. But all of those are with the firm. So let's talk a little bit about the sub-agency conversation. We've talked about this, right? So this was when we had the buyer who does not want representation. They want to represent themselves, but they need you. Hey, let me in the house. I need you to let me show the house. Take and show me the house. I don't need you as an agent. I don't need you to coach me. I'm fine. I am unrepresented. So, and we talked a little bit about how that could be with the same firm or a different firm. Either way, it's going to create that sub-agent, right? So, sub-agent of the seller is a sub-agent of the seller, making them a customer. If you do not have an agent agreement, and they're looking at a listing with your firm, you're a sub-agent. That make sense? By the way, you can't have sub-agency as a buyer agent too, right? If you hire this firm to be your buyer's agent, everybody at that firm is a sub-agent of the buyer too. Y'all all work the firm, which is why I'm trying to relate it to the previous slide, in that all agency agreements are with the firm. They're hiring the firm. Everybody at that firm works for them by default as a sub-agent. Picking up what I'm putting down? You sure? So if I hire ABC Realty and they have 100 agents, including yourself, you signed on behalf of ABC Realty. So now ABC Realty and its 100 agents work for me. You signed as my listing agent, but they are all sub-agents of me as the seller.
Step in if you, if you're out of pocket for some reason or whatever. I mean, it's the backup discussion, right?
It's exactly right. Because then and actually we get into that conversation because what happens if something happens to the person who signed the listing agreement? What if they leave the country? What if they go AWOL? We had one agent at one point in time who just disappeared. They had some health issues and they just checked out. We didn't see them for months.
Wow.
So because the listing agreements and all of our buyer agency agreements were with the firm, we had to service those clients because they hired the firm. So we had to call them and say, we don't know where she's at, but we'll help you because you hired the firm, we'll help you. And then later she surfaced and we settled it all up, but it was, sometimes things happen. So if it had not been with the firm, we wouldn't have been able to continue helping those clients.
So who gets the commission? Would it be the person that jumps in that helps, or is it, it wouldn't be like spread out between like 100 and something people, right?
Oh, great question. So that ultimately is going to depend upon your independent contractor agreement, but most of the time it is how much of the commission is generated do you get, and how much of the commission that is generated does the firm get? Meaning the
But I mean,
broker.
if
I got
somebody
you.
disappears,
In the disappearance case,
Yeah.
that was just, we would negotiate it. You know,
reinitiate.
Case by case.
just, yeah, case by case.
Okay.
You know, mhm.
Okay, I get it. That's where like the 40-60 comes in, or so forth like that. Like your firm gets
Yeah,
an
like
amount and you get.
let's just
an
say a 50-50 split. If it's a $3,000 commission, the agent gets $1,500 and the firm gets $1,500.
amount. Okay, yeah.
And you'll see a lot, and those will be the things that you'll see in your independent contractor agreement.
Unless you disappear, then you might not get any.
Very, very true. Very, very true. All right, so 3 main employment agreements: listing agreement, buyer agency agreement, property management agreement. Without one of these 3, you really don't have a job. You have to be hired to be an agent. So if you do not have a buyer agency agreement, if you do not have a listing agreement, and you do not have the ability to get the property management agreement signed, you are a volunteer. Which is, again, self-employment, which is a lot like unemployment. Listing agreement, buyer agreement, property management agreement. Now there's flavors of all of these agreements. Isn't that great? Instead of just 3, we're gonna learn like 30. It's gonna be fun.
Baskin Robbins.
Yeah, it's 31 flavors. I love it. Baskin Robbins, 31 flavors of buyer and seller and management agreements. Fundamentally, do you see where we're at so far? We're starting surface level, we're drilling down. General, universal, general, special, right? And then we're getting down into agency agreements. Property management's a general agreement. Buyer and listing agreement would be a special agreement. Under the buyer listing agreement, property management agreement, buyer agency agreement, we're gonna get into specifics of how those pan out. Following the hierarchy, maybe-ish. Maybe you need some more coffee. So creation of agency. So we do not, as I mentioned earlier, do not recognize this implied agency in North Carolina. The implied agency is born from actions, meaning you're acting like their agent, therefore you are their agent. In some parts of the country that happens, that is not something we recognize in North Carolina. You do not have an agency agreement in North Carolina unless you have an agency agreement. Express means, again, meeting in the minds. Do you? I do, right? Do you want me to be your agent? I do. Great, we have an agreement. We have an express agreement. All of our agency agreements must be express in North Carolina. Yeah.
What, should you get that out in writing? Because what if someone went like crazy and was like, okay, no, you're not my agent? Could you get like, that probably would never happen.
No,
but
you're right
just-
on, and that's actually exactly right. We ultimately, when I ask you the question, what agency agreements have to be in writing, the answer will be all of them
Eventually.
at some point.
Oh, okay.
We're going to talk about the kind of unique exception where we can have this oral buyer agency for a little while, but ultimately it all has to be reduced to writing before we do anything, before we actually start getting to contracts. So buyer agency can be a little bit oral, but ultimately in North Carolina everything gets to reduce to writing. Other parts of the country may recognize implied agency. I mean, hey, you were managing this property for him and then you were managing this property for him, and he didn't deny it and he let you do it, so yeah, y'all had an implied agreement. We don't do that here. Questions on that? So apparent authority. This is exactly kind of what I was leaning to. Apparent authority, you're hired to rent one property, your owners have more rentals, and so therefore you take tenants from this particular rental to that one, and take your overflow candidates to another property that you know he owns. Because they are taking leases, then it could be that you are creating that implied agency agreement, and therefore through the property of estoppel, you could be entitled to your commission. The reason, well, I won't say the reason, I just have to tell you this. I think of estoppel because in this case the landlord did not stop you from acting on their behalf. So because they did not stop you, then they would in fact have agreed to allowing this to happen.
Can't later come back and say I didn't say so that you could do it.
Right. Later, I can't come back, and this is a legal term that applies to a lot of different court situations. But the summation is, You didn't stop it from happening, so later you can't go back and be like, oh, I didn't let that happen. Yes, you did. You didn't stop it. You allowed it to happen. It's assuming you were giving consent because you did not stop it. That make sense? So that's the property of estoppel. And again, it would work with an apparent authority or implied agreement. So how can we represent buyers? Well, this should look familiar, or clients rather. This looks a little bit like what we talked about last class, right? You loved it? You loved it. We talked about buyer agency and seller agency and dual agency and seller sub-agency and designated agency. It was so fun. So much fun, in fact, that we're going to do it when you get back from your next break. Again.